All right, good afternoon, everyone. Welcome and thank you for joining us for the Domestic Violence Fatality Review Project's webinar entitled the Georgia Domestic Violence Benchbook, It's Not Just for Judges. My name is Jenny Asman, and I'm with the Georgia Commission on Family Violence. Also with me today is Taylor Tabb with the Coalition Against Domestic Violence, Joan Prittie, the Executive Director of Project SAFE, and Christy Showalter, who is the Director of Training and Membership with the Georgia Coalition Against Domestic Violence, who's helping us out with the webinar technical side of things today. Before we get started, I just want to go over some housekeeping notes. I want to make sure that everyone can hear us loud and clear. So if you can please use the control panel on the right side of your screen, click the little hand icon, which just raises your hand for us and lets us know that you can hear us and we're coming in loud and clear. All right, it looks like most people are able to hear us. All right, so if you do find that at any point you are having technical issues with hearing us, or if it's not coming in clear, the customer support line on your screen now is who you'll need to contact for assistance with that. Just know that dialing in on your phone for audio rather than just listening via computer is going to give you better sound quality. If you have any questions or comments during the webinar today, we encourage you to use the chat function in the chat box on the right side of your screen. And that's going to let Taylor, Joan, and I see the questions that you have, and only we will be able to see those. So throughout the webinar, we'll be accepting questions from you, and then if you have anything else you need to let us know or talk about, you can use the chat function for us. One of the most frequently asked questions we get is, are you going to be receiving the PowerPoint slides? After the webinar ends today, we will be sending those out to you, as well as an evaluation of the webinar today. So most times that can be used as documentation that you participated and attended this webinar today, so keep that for your records. All right, we just want to say thank you to the Georgia Criminal Justice Coordinating Council, who supports the Coalition Against Domestic Violence and the Commission on Family Violence and the Fatality Review Project. Our grant numbers are listed on your screen, so thank you to them for allowing us to bring you this webinar training today. All right, so before we move on from here, we just want to get a sense of who's in the audience today. If you could go ahead and use that chat function on the right side of your screen and just put in what agency or which of the following options up on your screen best describes the organization you're with today. Let's see. All right, we've got someone from the courts here, a domestic violence shelter, Georgia Legal Services, a victim advocacy program. All right, lots of advocates here. Private legal practice, a social worker in the school system, a prosecution-based VWAP, DFACS, an outpatient counseling program, Jewish Family and Career Services, drug court, social services, and the Salvation Army. All right, so quite a bit of variety here today on the webinar, and we're very thankful that you're here. We think that you are going to learn quite a bit from Joan as we get going on this webinar today. And just before we move on, just want to give an overview of the Fatality Review Project. This is a joint initiative of the Coalition Against Domestic Violence and the Commission on Family Violence. The webinar today is a sixth in a series of webinars that we've done this year, and these webinar series is in response to feedback we got from readers of the Fatality Review Report and our stakeholders who said that they wanted to hear from us more throughout the year. So we started this webinar series in response to that and focused on Fatality Review recommendations and implementation strategies. It's been really successful, and so we plan on bringing you more webinars in the coming year. So just keep an eye out for more announcements, and let us know in the evaluation you receive today if you have any ideas or needs that you have for training that we can potentially bring you next year. And all of the webinars in our series have been recorded. and other materials that we have available. They're all posted on our new Fatality Review website. So that's georgiafatalityreview.com. And you can visit that at any time and watch any of the webinars that we've recorded in the past and order any materials you need. And the webinar today will be posted in just a few weeks. So if you want to come back and watch it, you can always do that. So now I'm going to just turn things over to our guest presenter today, Joan Prittie, who is the Executive Director of Project SAFE and also the co-author of the Georgia Domestic Violence Benchbook.
All right, good afternoon, everyone. I am lucky enough that when I am facing my computer screen, I am also facing a window and can enjoy the blue sky and the sunny day that we have. I hope that's the case for everybody else here today, too. So this is the Georgia Domestic Violence Benchbook, 9th edition. When I talk about the benchbook, I have learned over the years that I have a set of concerns. And here's the first concern. That is, who would actually want to come and listen to someone talk about the benchbook? Y'all have proved this concern to be baseless with everyone signed up here, so we can move on from that. Here is the second concern that I'm always mindful of in talking about the benchbook, and that is that the material is pretty dry, and so I am going to do my best to present it in a way which will not induce this sort of reaction among any of you, and share some stories and other things that hopefully will help this be engaging and interesting for you as well. Here is the third concern that I have when I speak about the benchbook, and that is that listeners would think that I am presenting myself as some sort of expert in the wide range of topics that the benchbook covers. And truly I am not. But I did run across this definition of an expert a while back. An expert is a person who has made all the mistakes that can be made in a very narrow field. I'm not sure that we could call domestic violence a narrow field, but I will certainly cop to having made just about every mistake that one can make in it. I began working in domestic violence back in 1992, so really at the time when Georgia's Family Violence Act was passed and the Georgia Commission on Family Violence was created. I started doing this work, doing clemency petitions for battered women in prison who had killed their abusers. I also represented many men in prison who had killed their wives or girlfriends. And that whole process really changed the course of my career and my life and led me ultimately to Project SAFE 16 years ago. So in no way am I suggesting that I'm an expert in all of these areas unless we go by this definition here, and if we agree to that, then I will wear the mantle of expert. So have you ever wondered or perhaps been asked any of these kinds of questions? Does violence have to be recent to qualify for a TPO? Is there any limit on the number of times that someone can come before court and ask for a temporary protective order? There's a judge who always insists on notifying the respondent before ruling on an ex parte. Is that allowed? Or what about questions like these? Can a judge really remove a respondent's guns in an ex parte order? What about getting unemployment benefits for domestic violence related things? How does lethality factor analysis really work, and how might someone use that in a day-to-day basis? Is mediation ever okay? Or what about questions about the impact on children and how that might influence a court's decision. All of these kinds of questions and many, many more are addressed in the Georgia Domestic Violence Benchbook. The Benchbook began about 10 years ago now, and was meant to be a chapter in the regular Superior Court Benchbook. And when folks first started working on it, and all credit to Nancy Hunter, who was the first project director for the Benchbook, it became apparent pretty quickly that a chapter wasn't going to cut it, and that the Benchbook really needed to grow to become a standalone resource, and that is what it is today. And although it was designed initially for judges and is still, of course, called the Benchbook, it's meant to be something that anyone who's trying to understand these issues related to domestic violence here in Georgia, that anyone could access and use. So Nancy Hunter had the Benchbook project until she retired in 2009, and in 2010 the Institute for Continuing Judicial Education approached me about taking over, and so I have had the pleasure of working on the last 4 editions of the Benchbook. So a few caveats before we really get into it. There are some limitations to this. The landscape is always changing. When Nancy worked on the Benchbook, it was her full-time job year-round. I do this as a part-time contractor for a portion of the year with ICJE. And so things are changing. New law is being made. Policies are being issued at times when I am not working on the Benchbook, and so in that respect, it's never perfectly up to date. It is hard to catch so many details, and I find myself after the fact going, "Oh, darn it, I missed that. We've got to fix that for the next time, or we've got to add that thing." And there is always the very real challenge of trying to balance breadth of information and the scope of the Benchbook with accessibility and ease of use, not to have it be overwhelming. But there are so many benefits to this resource, and I'm glad that it is being promoted to a wider audience. It is a great quick reference guide. It is a wonderful source of training material for your internal training, for your own self-education. It's a wonderful conversation and debate starter. There is so much, of course, about this issue of domestic violence that remains unresolved, controversial, where we don't have consensus or agreement on the right things to do. And I'll walk you through some examples of that in the Benchbook. And then it's a wonderful education and advocacy tool to share with people in your community, on your task force, with the judges in your circuit, and to help advance people's knowledge and comfort with the subject matter. Some of you may have seen this. This is what the Benchbook used to look like. And you see a ginormous 3-ring binder with the Georgia Superior Court Benchbook on it. And in fact, you may know some folks, or you may be one of those folks who's got that old thing on a bookshelf somewhere, and you think, "Oh, I've got the Benchbook." And no, it's not this anymore. You can just recycle this. Here is where you find the Benchbook. It's at the Institute of Continuing Judicial Education website, and the URL is here on this slide, and you see the screenshot of what the Benchbook looks like. You'll notice on the screenshot that it says 8th edition, and you'll recall from the beginning slide that I'm talking about the 9th edition. Unfortunately, the 9th edition is not yet up on ICJA's website. I will let organizers know as soon as it is. But I turn my content in to ICJE in the summer, and then they have wonderful folks there who do all of the hyperlinking and the manual indexing in the book that you see over on the side, and that is what really gives the Benchbook its functionality and makes it not overwhelming to use, and that all takes time. They were poised to upload it the other day and were having hard drive issues that then affected connectivity with their web server, and they are still trying to figure out that issue. So I apologize for the technical troubles over there, but we will get that 9th edition up as soon as possible. The Benchbook is big, and this is why we don't print it out anymore and put it in those giant 3-ring binders. It's not quite this big. This photo is actually a picture of Wikipedia, but it is many hundreds of pages long, and so I don't advise printing it out at all. I actually keep it on my phone. I find it's quite handy to refer to there, but it is meant to be utilized as an online tool. So what is in the Benchbook? There are 5 chapters covering civil protective orders, jurisdiction and procedure, remedies, settlements and orders, criminal law, and evidence. And in addition, there are 22 appendices that have information on topics which are related to the statutory and case law that are covered in the first 5 chapters. And these 22 appendices really cover a wide array of material. And so what I'm going to do for the rest of the webinar is really give you a roadmap, walk you through some of the features and some of the content in the current edition, the 9th edition of the Benchbook, and really give you an overview of changes that have been made in the last 4 editions that I have been working on. So chapters 1 through 5 are in outline format, covering both statutory and case law. It's great for training or a refresher or for getting a lot of detail about certain aspects of the law, and it is a wonderful tool for doing some advocacy with judges. Here's just an example of what a portion of a page looks like in this sort of outline format. And so, again, hearkening back to my concern that I not put anyone to sleep, you can see by that why I would not just kind of go through a page-by-page walkthrough of the Benchbook. In those first several chapters, we really pay a lot of attention to civil protective orders, stalking orders, and temporary protective orders. And I have found in the years that I've been doing this that I get a number of calls and emails about a couple of issues in particular that are worrisome to people that seem to come up quite a few places over across the state. And so I wanted to share those. The first has to do with ex parte orders and the practice that I understand some judges have of insisting on notifying the respondent in the family violence protective order of the ex parte hearing, basically making it not ex parte anymore. When you read the statute very carefully, you see that contact with the respondent at this juncture is not expressly forbidden. But I think it is very important and telling that the statute uses the phrase ex parte. And of course that means for the benefit of one party without notice to the adverse party. Ex parte hearings are so unusual in law. Our whole legal system is based on the adversarial process of equal footing and access to adverse parties presenting their cases, making their proof before a judge and an impartial judge or jury making that determination. And so it is significant I believe, that the statute uses ex parte. I think that that is what the legislature intended when they passed the law. They did not use any other word like interim or emergency or something like that. And of course, we have such a potential for danger if we're going around notifying respondents of these things prior to there being any protections put into place. And so this seems to be an issue where there's again, quite a bit of difference in interpretation across the state, but this is one where hopefully the benchbook could help educate judges on what, again, I believe the legislative intent was here. Another issue that I hear about quite a lot these days has to do with the 30-day hearing or the second hearing. The statute 1913(3)(c) states that no case later than 30 days after the filing of a petition, a hearing shall be held. Now, I know in some places, if a judge winds up denying the ex parte, then that's it. Everything's done. And in fact, in a number of jurisdictions across the state, I understand that people come to the judge first prior to seeing a clerk, so that if a judge denies the petition, there actually is no record of anything ever having been filed. But in a number of places, I understand that courts are reading this statute, seeing that a hearing shall be held, and going ahead and setting a hearing even when they deny ex parte relief, whether or not the petitioner understands or decides to proceed. And so here we would have a very similar danger to the practice in the slide before of notifying the respondent at the ex parte phase, and that is that if we give notice to the respondent of a second hearing coming up, but we have no protections in place for the petitioner, we have potential for a real dangerous situation. So really, like any civil case, if the ex parte relief is denied, then the petitioner should be given the choice whether or not to dismiss the petition or whether or not to hold the hearing. So this is addressed in the second chapter. There are actually some sample forms that are in use in Fulton County, and you can find those in chapter 2, but where they actually, check the box, giving the petitioner the choice to have a hearing, even though the ex parte is denied, or to go ahead and dismiss the petition at that time. And of course, in any event, if the petitioner isn't already, that person should be connected to a domestic violence program or a shelter, whatever is available in the community to do safety planning and to shore up other resources or provisions for that person. So moving out of the chapters, then we get into the 22 appendices covering different material related to law and domestic violence. And the first one is dynamics of domestic violence. This is one that got a pretty big overhaul with the 6th edition. It's done in a question and answer format. It is written with judges in mind, but it's useful for everyone. It talks about the different kinds of domestic violence, different perpetrators, different causes of domestic violence. Some of the research that's out there really is a great basic introduction or refresher course. And like all of the appendices, the direction that we've been taking with this in the last 4 editions is to try to make this as user-friendly as possible, to keep the information pretty brief, to chunk it up into sections and subheadings, make it easy to find, easy to digest. And so that's what we've done here. Appendix B is all about assessing for lethality. Lethality factors, as many of you probably know, are conditions or circumstances that indicate that a victim of domestic violence might be at higher risk for serious injury or even death. In the Benchbook, we divide lethality factors into three categories. Quantitative, which has to do with the nature or severity or frequency of the violence itself. Environmental, which is the larger landscape or context that the relationship is in, and then qualitative, which has to do with the power and control that's at issue in the relationship. And so, if you look at research that's out there, there's a whole lot of instruments about lethality factors. I've seen lists as long as 40, 45 factors. I've seen lists as short as 5. We've gone with something in the middle here. So in the quantitative lethality factors, the ones that we focus on are strangulation or attempted strangulation, sexual assault, an increase in violent attacks, threats to kill, access to firearms, and animal or pet abuse. So with strangulation, for example, that's one where, according to some of the research, we see 10 times greater likelihood of being killed if there is strangulation in that relationship. Or in terms of threats to kill, that's one where research has shown a 15 times greater likelihood of death if a victim has been threatened with death. If someone has been threatened with a gun in a domestic violence relationship, that person is at 20 times greater likelihood of being killed. In terms of the environmental lethality factors, the ones we have in there are unemployment, which I believe is the most statistically significant environmental lethality factor. We have a 4 times greater risk of homicide when the perpetrator is unemployed. We also have, in that category, we have things like substance abuse, access to the victim, what I always call the oh duh lethality factor, because it's so obvious we forget about it, and then pregnancy. And then among the qualitative lethality factors, we have things like controlling or extremely jealous behavior, the victim's efforts to leave the relationship or sever the relationship in some way, depression or thoughts of suicide on the part of the batterer, harassment or stalking type behavior, and then the victim's own terror, which of course is something that we always need to take seriously. Victims are eerily good at predicting when they are in real danger. They're not necessarily as good at predicting their own safety. They may not appreciate the danger they're in. They may minimize as a coping strategy. In fact, I will never forget one of the clemency clients that I worked with, a woman from North Georgia who had actually been shot in the shoulder by her abusive husband, and it was the only thing that we could find any record of. And I made many trips to the women's prison to interview her and talk to her about her history and try to sort of piece together what had been going on in this relationship. And she was not talkative, to say the least, and I just couldn't believe that was the only thing there, this gunshot to the shoulder, and but she never talked about anything else. And finally one day I got actually a little bit frustrated, and I just said, I can't believe this is the only thing that ever happened to you, that out of the clear blue sky he just up and shot you one day and never did anything else. And she looked up at me with this kind of incredulous expression on her face, and she said, "Honey, you mean you want to know about all the times he missed?" Apparently he used to pull out his gun and shoot at her quite often in the carport, in the driveway, out even in their backyard. He called it making her dance. But her coping strategy was to not focus on all of those kinds of things and just sort of filter down to the one time that he had actually shot her. So all that's to say that survivors of domestic violence may minimize their experience. They may not appreciate all of the signs of danger in their relationship, but when they say they are terrified, even if we can't quite discern why, we certainly need to take that seriously as a lethality factor. So just as a quick demonstration of how lethality factor analysis can work and the difference that it can make and why we want judges and law enforcement and as well as advocates and everyone dealing with domestic violence to understand how this works. And because it focuses us on what is really significant in relationships characterized by domestic violence, rather than on what we may have traditionally looked at in domestic violence, which usually is how serious, how severe is the crime that may be at issue, and how serious is someone's injuries. I think that historically has been how many folks would look at an act of domestic violence to determine if it was really significant or serious. And we need to move away from this. So here's something that happened here in Clark County. This was a guy and a girl who'd been living together, and the woman moved out. She took an apartment, ground floor apartment here in town, and her ex-boyfriend was not letting her go. He kept calling her, leaving voicemails, baby, please take me back, you know I didn't mean it, please give me one more chance. He would leave flowers and notes taped to her door, stuffed animals on the doorstep, all of that kind of stuff. One day he came over and refused to leave. He's out on the doorstep, kind of pacing in front of the window. She can see him. And he said, if you don't take me back, I'm going to go get my auntie's gun and take myself out. It's very dramatic. She winds up calling 911, and the police come over and they arrest him. He's still there. They arrest him for criminal trespass. So in that situation, if we're looking at it in this sort of traditional point of view, we would notice that there were no actual weapons involved. He said he could go get his aunt's gun, but he didn't have anything on him. There was no violent contact. She was inside the apartment. He was outside the apartment, so there was no injury. When the police did a criminal history check, there was no criminal history other than a DUI some years earlier. And you might interpret the notes and the flowers and all of that as, just a guy trying to get his woman back. And so looked at from that point of view, I think we might think that this is not a very serious case, that this is no injury, not a serious crime, not something we particularly need to worry about. But if we use lethality factor analysis and we think about this in a different way, we would notice that he had access to a handgun, his aunt's gun. We have stalking after a separation. We have threats of suicide. We have the ODA lethality factor, access to the victim. If you talk to the victim in a safe place, she would have confirmed that the DUI was not an isolated thing, that he did abuse alcohol. She would let you know that he was currently unemployed, that there actually had been an increase in violence prior to the breakup, although she'd not called 911 previously. Of course, we have the recent breakup, and she would confirm that she was pregnant. So in that same situation, now we're looking at 9 lethality factors. And if I recall correctly, I believe the average number of lethality factors possessed by a homicide victim in domestic violence is 7. So it changes how you view the situation. And in fact, in this situation, he did come back just a couple of months later to that apartment. He shot her through the window while she was holding the baby that she had by this time delivered. Amazingly, they both survived. But this is the sort of information that is extremely helpful for law enforcement to be putting on police reports, and for advocates or attorneys to be putting in petitions for temporary protective orders. After the section on the petition where you actually write about the crime that sort of you're hanging your hat on, the underlying crime for the TPO, there is another section which invites you to share things that have occurred on other occasions, and that is a great place to talk about lethality factors that may be present in the relationship to help educate the judges about how truly potentially dangerous a situation may be, particularly if the underlying crime that you're working with is something like criminal trespass or criminal damage to property or something else that might easily be misinterpreted as not terribly serious. Appendix E deals with firearms. There's lots of information there on firearms and temporary protective orders, including U.S. v. Castleman, which is a Supreme Court case from the end of 2014 that clarifies requirements for removal under federal law, clarifies that the violence that is required in the federal code is actually met by the common law interpretation of battery, that is offensive touching. So we don't actually have to have violence like something which causes injury in order for those federal provisions to kick in. That was Castleman's argument. But again, that physical force in this context of domestic violence can be much less than that in terms of shoving or slapping or that kind of thing. Again, our common law understanding of battery, and so that is included in the newer information. Quite a bit on recommended practices. I also threw in just some interesting things that other states are doing with regard to domestic violence and firearms. Again, part of that conversation starter, debate starter function of this resource as well. Appendix H covers immigrants and refugees, and going back, I think probably to the beginning of the bench book, or near beginning when this was included, we owe a debt to Aparna Bhattacharya for providing a great deal of the content and updates here. But there's an awful lot of information, vocabulary and terminology, things about work authorization, various kinds of relief for survivors of domestic violence. Then we have, of course, the Georgia laws which have been passed in the last 3-4 years, the Illegal Immigration Reform and Enforcement Act, Georgia Security and Immigration Compliance Act. Those pieces of law are covered in this section. There's a good bit of information on VAWA confidentiality. And then, of course, a table of resources, too, where you can find more information and actual people to provide assistance if you're dealing with issues relating to immigrants and refugees in domestic violence. Appendix I covers mental illness and domestic violence, and this is one that got quite an overhaul for the 9th edition. So if you're looking at the 8th, it's going to be totally different. This is an example of, again, trying to make it easy to read, user-friendly, simple to digest. We actually removed a lot of information that had been in previous iterations of the bench book, a lot of things about medications and such. We've simplified it down to a question and answer format with a lot of focus on signs and symptoms. There's a great resource that we got permission to reprint, a judge's guide for mental illness in the courtroom. And then we've also paid special attention to the issue of psychological evaluations and trying to point out that someone should have, in order to be most helpful in cases of domestic violence, not only credentials and experience in the realm of mental health, but someone should also have a good grounding and education in domestic violence to be able to understand both of those issues if providing any kind of psychological evaluation for the court system. Appendix K covers mediation, and this is a good example of where there is not consensus, where there are quite differing perspectives on the topic, and I think this is a good example of opposing views being presented on the same topic. And so we have guidelines from the Georgia Commission on Dispute Resolution, which were initially issued 20 years ago but revised more recently. And then we have a question and answer section about mediation in cases of domestic violence, and then a statement of concerns that had been prepared by the Commission and the Georgia Coalition Against Domestic Violence. And so this is one, again, that presents differing viewpoints and leaves it up to practitioners to consider these issues, talk about these issues, and try to implement what seems to be the safest and most effective practice. Appendix O discusses children and domestic violence. In the early iterations of the Benchbook, issues of domestic violence impact on children, as well as sort of logistical issues of visitation and custody and whatnot, were combined into one appendix. I've bifurcated this, and so there is a separate appendix about visitation, custody, and support, and then this one covering more the impact on children. So the effects of witnessing, the factors that courts are recommended to consider in assessing the impact of domestic violence on children, risk and protective factors. And there's a good discussion of the Nicholson case. This was a federal case out of New York. It was a class action lawsuit brought by parents, mothers, really survivors of domestic violence whose children had been removed as a policy by the local equivalent of our DFACS. And so the parents got together and filed this class action lawsuit and ultimately prevailed in that there could not just be a blanket policy that all children ought to be removed when there's domestic violence in the home. But in doing that, the court did really quite a thorough job in bringing in leading experts on this issue to give testimony about the impact, about the various risks posed to children, about the kinds of protective factors, and helping to really illuminate this issue. Appendix P is another one of the newer appendices that covers cyberstalking and digital abuse. So we have an overview. Of course, we have our updates from the last couple of years with revenge porn and harassing communications. We cover some other things. Jurisdiction is kind of interesting. So it's different in criminal stalking than it is in civil. If you're looking at a civil order, and we had that issue come up in Clark County, and that was this Huggins v. Boyd case, where there wasn't any jurisdiction for a protective order here over a non-Georgia respondent who was typing and sending the emails from South Carolina. So that was kind of an interesting case that we experienced here. But this is one, probably it seems like we could update this just about every every month just to try to keep up with the ways that people abuse one another utilizing technology. Appendix R deals with restitution, victims' compensation, and public benefits. And so we have an overview of these kinds of issues, all relating to really economic security is what they have in common. Some recommendations for best practices. The section covers Scott v. Butler, and then of course the legislation that was passed earlier this year, HB 117. Both of those deal with unemployment benefits for survivors of domestic violence. So we had the Scott v. Butler case in 2014, where the court explaining that yes, survivors of domestic violence may be eligible for unemployment benefits in certain circumstances, and then HB 117 really clarifies that in, let's see, it's 3482, I think, is the code section that amends. But so now we know and have laid out in statutory law the circumstances under which someone may qualify for those benefits. I've put a picture of a washing machine here and laundry because whenever I think about these sorts of issues and the ability in particular of courts to award any kind of economic sort of relief for survivors, or the ability of advocates, social workers and so forth to seek this kind of relief or provide this kind of assistance. Whenever I think about this, I think about Connie Sponsler, a veteran advocate from the Midwest who a very long time ago told the story about a woman in their community that everybody was worried about. And I'm sure many of you can think of somebody like that in your community. Someone who was familiar to the advocates, familiar to law enforcement, familiar to the prosecutors' offices. Everybody in town was worried about this lady and her children, the escalating violence that she was facing in that marriage. And everyone was pretty frustrated too, because she would take some steps to try to get out of that situation. She would call 911 or maybe seek a protective order, but then she would always back away from those steps. And people were just getting increasingly annoyed and frustrated that they couldn't seem to help her. And finally, Connie went and sat down with this woman and talked to her and said, just is there anything, just anything you can think of that would help you get out of this situation? Forget whatever we've tried before, just anything. And she said, well, if I had a washer, I think I could leave him. And the woman went on to explain that she had a lot of children and that she had to borrow her husband's car and take all of the laundry in the car. She had to get money from her husband for detergent and fabric softener and to use the laundromat. She had to drive to the laundromat and spend all day at the laundromat. And she was not going to let her kids go to school in dirty, raggedy clothes. And Connie couldn't believe it. A washer? But that in her mind was the stumbling block. So certainly not every situation is that simple, and a washing machine is not going to be everybody's ticket to freedom. But I think it's important for us to remember the power of these sorts of remedies and to try to seek them and award them when we can. Appendix T covers strangulation. It's again in a question and answer format. It has a chart for signs and symptoms. It gives an overview and general information. And of course, our aggravated assault statute, 16-521, was amended, I think year before last it was, to include strangulation and suffocation as acts of aggravated assault. So now that is a felony in the state of Georgia. Prior to that, it was most often prosecuted as a misdemeanor. But it's not just the addition of strangulation as a felony that led me to want to make a standalone appendix for strangulation. Of course, we cover it in Appendix B, lethality factors, but strangulation truly is unique among lethality factors because of the gap, and gap really doesn't do it justice. The chasm between the potential danger of strangulation and the perception that people have of it. People still call it choking. You know, we choke on food, but people call it choking. People don't realize the danger. We had a hotline caller I'll never forget, who was pregnant at the time of the call, and knowing that was a lethality factor, the advocate on the hotline was just asking some questions about if things were getting worse during the pregnancy, anything like that, and the woman said, "Oh, no, since I've been pregnant, it's been so much better. He only chokes me now." And it turns out that she had been strangled to the point of unconsciousness many times, and but her perception was that it was getting better, not that it was getting worse. So we still have a great deal of work to do to change people's perceptions, to help everyone from our first responders who may be going out and encountering this, to our jury pools, to the clients that we work with and our own staff, for people to understand the significance of this lethality factor in particular. People don't tend to die of strangulation when they've experienced strangulation in the relationship. They tend to die of something else, but the strangulation is an indicator of the power and control that's at play, and of the abuser's willingness to engage in at least the most incredibly reckless kind of behavior. Another thing that I find striking about strangulation is how easily mimicked it is. I can remember leaving our emergency shelter rather late one night. It must have been about 8:30 or maybe 9 o'clock. And as I was passing the central staircase on the way out the door, there was a mom in the shelter standing near the bottom of the staircase, and she was trying to get her 6-year-old son to go upstairs and go to bed. And he was not wanting that and was literally dragging his feet up the staircase, whining, "I don't want to go to bed." And I actually stopped for a minute and, said something like, "Son, you need to mind your mama." She was quite a petite woman, and he was a few steps ahead of her on the stairwell, which actually put him, even at 6 years old, almost to her height. She urged him on up the steps again, and he swung around, whipped his arm around, held it out straight, grabbed her throat, pressing inward with his thumb and his fingers, squeezing on either side of her throat. And he steeled his jaw and gritted his teeth, and he said, "I said I don't want to." And that woman collapsed onto her knees. The tears just sprang to her eyes. She was whispering, "Please stop, you're hurting me," as though she were speaking to her abuser and not her 6-year-old child. strangulation is unique among lethality factors, and we need to continue to pursue this aggressively in our state and to help people understand its significance in the realm of domestic violence. Appendix V is new this year. It covers VAWA housing protections. It includes an overview, admissions, evictions, lease bifurcations, and there's a great piece from the National Housing Law Project that we got permission to reprint, which again provides a good question and answer format, a lot of information about this and the protections that are available to people who are in federally subsidized housing when they are having to deal with domestic violence. So I've not gone through every appendix in the bench book, but I've tried to give you a sampling of the mix and range of material that's in there, the format, the way it's laid out. There are other features to the bench book as well. There's a whole section on resources, a bibliography, a case citation index, a regular topic index, and then in addition to the hyperlinked main table of contents, there are tables of contents for each appendix. So again, to try to make everything as easy to find as possible. And so I just want to leave you with a final thought and a story before we open it up for questions to conclude the webinar. But whenever we're talking about statutory law, about case law, about research and data and all the sorts of things that are included in the bench book, all the sorts of things I've been talking about this afternoon, we need to remember that each piece of information, each law, each bit of data has come from somebody's pain, has come from somebody's agonizing experience of loss, or somebody's story of survival, of dealing with domestic violence. It all comes from people. And while we may hope that we can transform their lives, help people who are struggling with this issue, that isn't always possible, but it doesn't mean that our efforts are not worthwhile. I've got this photo of a balled up piece of paper here. It reminds me of a letter I received from one of my clemency clients, I don't know, probably about 6 months or so after she was released from prison on an early parole from her life sentence for killing her abusive husband. The woman could barely read and write. I mean, really, she was illiterate. And this letter was about 3 pages long. She had written it painstakingly in pencil. I could see so many places where she had erased the words to make corrections, some places even erasing through the paper. Then when she got it the way she wanted it, she had carefully traced over all of the words in pen. And the 3 pages really detailed how difficult, or impossible, really, her life was since she had gotten out of prison. She couldn't find a job. She just wasn't, being accepted in the community. There just didn't seem to be any hope for any sort of future for her, and she was quite despondent. And when I got that letter, I was so dismayed that I wound up wadding it up and sticking it in just the back of a desk drawer in my home office. She wrote a P.S. and at the time that I first got that letter, even that P.S. Really upset me. She had written, P.S. Thank you. Thank you for listening. You were the only person to treat me like a human being and not some evil old woman who killed her husband. When I first got that letter, I thought, thank you for listening? Really? Anyone could do that. What about thank you for your rock star legal skills that got me out of prison on my life sentence? Or thank you for spending 2 years of your life on my case. But thank you for listening. As you might have imagined, my perspective has since changed, and that letter is one of my real treasures. We may not always be able to truly help or transform someone's life, but we can do a lot to be of service, and it almost always starts by how we listen. And again, no matter what our role is, whether it's judge, attorney, advocate, social worker, or counselor, how we listen to the people that we work with can be, as it was for that woman, the most important thing that we do. So I want to thank you all for your time, for joining us on this gorgeous afternoon, and choosing to be a part in this webinar. And if I can, I don't see any questions in my message box. I'm not sure if the organizers need to do something to make that happen, but I believe we've got time for questions, yes?
So Joan, this is Taylor. Can you say again when the new edition will be available?
Well, any moment now. Again, the content has been finished. The hyperlinking and indexing has been finished. What the holdup is now are technical issues, actual breakdowns that I understand are in the process of being fixed. But we expect it really just any time now.
Okay, and I'll just repeat again too that Joan is going to email us the updated link when it's ready, and we have everybody's email address that was on the call today, and we'll send an updated link. Another question, do you have any idea to what degree judges use the benchbook, and how are they encouraged to use it? So I guess the question would be, do we know how much they're using it, and how do they find out about it?
Right. So, the short and sweet answer to that question is no, I don't have any idea. But the longer answer is that because this is a product of the Institute for Continuing Judicial Education, which is the body that puts out, I would say, most of the continuing ed material that judges utilize. I do know that they are informed of the existence of the benchbook, and I believe are sent a link to it directly. I'm not 100% sure of this. I know anecdotally, because I've gotten calls from them, that there are judges who anticipate each new edition of the benchbook, look for the changes, call me when they have questions or comments, or to talk about things in it. So we certainly have among judges benchbook champions. I think also the Georgia Commission on Family Violence in recent years, not maybe perhaps so much earlier, but in recent years has taken a more active role in promoting the benchbook. One of the ways that judges learn about the benchbook or learn about its updates, because again, often judges may have, that old binder that's 6 or 7 years old at this point, and they don't realize how much content has been added, not to mention all the statutory and case law changes. So, if people through their task forces or advocates themselves or attorneys can say, you know, Judge, are you familiar with the Georgia Domestic Violence Benchbook, the 9th edition, the new one? That is a way that judges can learn about this. I think we do have a little bit of a hangover from the fact that the Benchbook started out as the Superior Court Judge Domestic Violence Benchbook. And for a while, the magistrate judges were writing their own Benchbook. I don't know if they're still doing that. I kind of don't think so. And I don't know about the state court judges. And so I talk about the Benchbook a great deal. I have done an online class for magistrate judges statewide for many years now, and I talk about the Benchbook there. I've also done presentations the last several years for Superior Court judges at their annual meeting. I do not get in front of state court judges myself, and I would suspect that is a bit of a gap. And again, it's great if people just in their own communities will mention it and engage it. How is it used? You know, they use it as reference. They use it to get guidance on things. It's not authority. It's not gospel. A judge isn't going to take the page out of the Benchbook and be like, well, if the Benchbook says, then I'm certainly going to do it that way. But they are going to, most of them, consider it and give it weight. And if they want to do further checking to make sure that it's accurate, then then they can do that.
Okay. So this question is in a similar vein. Who would you recommend that people send this webinar link to once it's posted online? So, we'll be posting this, we'll be archiving the webinar so people can share it with colleagues once that weren't able to attend today. But Joan, I'm just wondering, do you have suggestions for who should be listening to it?
I would love it if people would recommend this to members of their local domestic violence task forces. I would also love it. I'm thinking of, my organization, Project SAFE. Of course, I've done this live in a staff meeting for my staff. But I would love it if people who work for domestic violence organizations would make the link available for their own staff. It's just, like I said, a quick roadmap for people to understand what's in the Benchbook. If people wanted to, if they would make it available to their judicial delegation in their own communities, just as an FYI, that again would be a terrific way for the word to get out there.
Okay. And last question. This one is sort of for you, Joan, but it's also sort of for the entire group. So someone wanted to know that with regard to notification at ex parte hearings, are there any jurisdictions requiring notice to the respondent? I've heard of this happening in one or two jurisdictions, and I wanted to pose it to the rest of the attendees on the webinar. If you could just type into your chat box to let us know if that is also happening in your circuit. Are you familiar with that, Joan?
Well, that's what I was talking about in that slide about ex parte orders. That was one of the questions I get a lot, that people bring up, that, oh, there's this judge that when you go with a petition, they require, contacting the respondent. And that's why I put that information about the statute's specific use of the phrase ex parte to indicate that the relief at that juncture was intended to be without notice to the respondent. If the legislature meant for it to be with notice, they could have said something like emergency relief or interim relief rather than ex parte relief. So while the statute doesn't forbid it expressly, I think the intent of the statute is for that not to occur, but it is my understanding that that does occur in quite a few places. Now, I'm not sure where I have a question, would be curious, is if it's really a requirement in a particular judicial circuit or if it is just individual judges who are choosing that. Because there is, I hear that a lot too, where a circuit might have 3 judges and all 3 of them have slightly different processes for temporary protective orders.
Okay, that's the last questions we've got here. If anybody else has any more, go ahead and type them into the chat box now. All right. And just to let everyone know again, there are no certificates of attendance for this webinar, but you will be receiving an email that you attended today. Okay. All right. Thank you so much, everyone, for attending the webinar today. Thank you, Joan, for training us on this great resource and how we can use it in the work that we do. Please be looking out for an email from us with an evaluation and let us know about any other webinars we can bring to you in the coming year. Have a great weekend.